the Estate First Masterclass webinar series. We're excited to be bringing this series to you. And my name is Anne Jansen. I'm accredited succession law specialist with Estate First Lawyers. And I'd like to introduce you to our two presenters for this webinar. So firstly, I'll introduce you to Josh. So Josh, give us a wave.
Hello, everyone.
Yeah. So, and also to Kylie Costigan, who I've been working with for many years now, and she also is an accredited succession law specialist and senior associate like Josh is with the firm. Kylie.
Hi, everyone.
Okay, so thank you for joining us. Now, this masterclass is going to look at two case studies. So let's just have a look at that. The first case study is going to really focus on the power of testamentary trusts in wills. And we will look at a one family case study. It's nice and practical. It will look very similar to a lot of the clients that you see. And the second case study, which Kylie will do, so Josh will do the first one, and then the second one Kylie will do, and we will look at that same family, but now they are a blended family, and what other complications or interest comes up from a blended family situation. All right, so okay, so before we start, I just want to go through the purpose of the education that we do. And our first purpose, of course, is to give you greater knowledge and understanding of the wonderful, in-depth, complicated topic of estate planning. And so we don't want you to become gurus on it, but what our purpose is that you will feel really comfortable and confident when you talk to your clients, that you're giving them additional value. And I picked the picture of Einstein, and then I looked at his hair and I thought that's exactly how my hair looks in the morning. Okay, so purpose number two. What I want to do, or what Kylie and Josh want to do, is we want to make this very relevant. So it's not enough to go away with a lot of head knowledge, because you'll forget it over time. But if we can give you some tips and build some conversational bridges with your client, so that when your client says, oh, I've got an up-to-date will, you know, how do you respond to that when you know it's probably not sufficient? So we're going to give you some ideas and bridges so you can start an estate planning conversation in a way that is just seamless and easy. And purpose number three, the final of the three purposes of our webinars, is to make sure that when you have your estate planning conversations, which are definitely in the best interests of your client to have, because if estate planning is not done well or is not done at all, your client will face problems later on down the track. So it's the final piece in your financial advice solution for them. But when you do have that conversation and you are value adding, you also have to make sure that you're doing it in a way that remains compliant with your own rules of your own industry, and that you don't slip into giving them legal advice or legal solutions. What you are doing is identifying the triggers and also the opportunities that they can take that they may not have taken, without slipping into providing them with legal solutions or legal advice. Okay, so a quick word about us. Who are we? Who is Estate First Lawyers? Well, we're a firm that specialises in estate planning law. We also do estate administration law, so we see our clients' estate plan through to the end. We do not get involved in estate litigation, because that would take us off our focus of providing estate planning to prevent estate litigation in the first place. We have one of the largest teams in Australia with 6 career dedicated estate planning lawyers. All of them just love this space and only want to be in this space. We provide estate planning services Australia-wide, and as you may know from the opening slide, we are in May 2020 And so we are still in the middle of the COVID environment. We have worked very hard this year to provide an Australia-wide service. We were previously Queensland, New South Wales and Victoria. Now we offer an Australia-wide service, and it's the uptake of virtual meetings has really allowed us to go there. So we offer a face-to-face service, of course, and we also offer a virtual service or a contact-free estate planning service. And hopefully the COVID situation will end soon. And just on that point, I thought I'd share with you a little joke that's going around the office. So we've got Time Traveller, what year is it? And I say, it's 2020, and the Time Traveller's response, yeah. And it's been hard on all of us, but hopefully we are well and truly on the other side of the curve. Okay, so now I'm going to hand you over to Josh Philo, Senior Associate with the firm, and he's going to take you through case study number 1, which is a one-family unit, and we're going to look at asset protection and how testamentary trusts play into that. Okay, Josh, over to you.
Thank you, Anne. Thank you for joining us, and everyone. A quick disclaimer. All the information we're going to give today on the case studies is all general in nature, so you can't take anything direct in relation to your clients, but please feel free to let us know if you've got any questions. The beauty with webinars is you can do it from home, and so we've obviously made the effort in the office today, but watching the webinar at home, you can choose to look like the person on the right-hand side if you'd like. As Anne mentioned, we're doing this in a couple of different case studies. The first case study I'm going to look at is a single family. And so with the diagram on the screen, we have Bruce and Kathy. Bruce and Kathy are a married couple. Bruce is 61, Kathy is 56. Bruce worked in the government as a manager, but he retired early due to a heart condition. Kathy's still in good health, still does part-time teaching. They have 3 children of their union, as you can see from the diagram. Michael, who is 32, Jane is 28, and Bianca, who is 19. Michael is a school principal. He's married and he's got 3 kids, as you can see from the picture. Jane's also married to Bart, and they have 1 young child. Kathy and Bruce have a somewhat difficult relationship with Bart, and they're a bit worried about Jane and Bart's relationship. So they're feeling that it could be a bit rocky. Bianca, who's 19, still studying at uni. She's studying business. She's a bit unsure of what she wants to do. They describe her as their baby, and so consequently she still lives at home and is financially dependent on Bruce and Kathy. Bruce and Kathy have the following assets. So this is what they own. They've got their residence, which is at Camp Hill. They also have their investment property, which is in Kathy's name, worth $600,000. Bank account in joint names. Superannuation, so they both have super. Bruce is in pension phase because he's retired, and Kathy, being part-time work, is still in accumulation phase with $350,000. So they've come to see you for financial advice, and as part of that, you've asked them whether they have current wills in place. They've said yes, they do. And they have current wills in place, leaving everything to each other and then equally between the 3 kids. Is that the end of the conversation? No, it isn't. As Anne mentioned, we want to give you some bridges to be able to ask questions and give information, general information on estate planning. they have a combined estate of over $2 million, which, if they both pass away, equates to over $700,000 per child. Their current wills are very standard. It's not a question, or not just a question, of what they say that they want or need in their estate planning, but more so about the quality of the inheritance vehicle that they are leaving for the kids. To give you an example, Bruce and Kathy, they mentioned about Michael being a school principal with 3 children. So they may be interested in looking at some potential tax effective ways to pass the inheritance to Michael. The current plan basically leaves him his 1/3 share in his own name, which isn't great from a tax perspective. They've also mentioned to you about Bart and Jane and the concerns that they have in that regard. So they could be interested in looking at some asset protection for Jane's inheritance, which their current standard wills don't do. In relation to Bianca, they talked about the fact that she's still 19 years of age, a bit unsure of what she wants to do, and so they could be interested in looking at a financial framework around Bianca's inheritance, around how she can and when she can get access to the capital, how she can utilize it. They may be interested in looking at an independent controller or gap controller for Bianca until she's older. And of course, asset protection for Michael, in addition to the tax benefits, and tax breaks for Jane, in addition to the asset protection. These are all the things that a better plan, such as a testamentary trust, may be able to achieve for them. I want to have a look at that plan. So this is an example of what a better plan might look like for Bruce and Kathy. In the orange box up the top, they're still leaving everything to each other. So that hasn't changed. And they're still dividing the estate 3 ways. That also hasn't changed. But the difference is they've given the kids the ability to take their inheritance in a testamentary trust structure that provides them with some better tax flexibility and asset protection. So how do they work? How does a testamentary trust work? We'll use Michael as the example. In a testamentary trust, he would be one of the potential beneficiaries of his trust, along with his other children are also included as potential beneficiaries, along with their descendants, so lineal descendants, companies and trusts he might set up for tax purposes, and potentially churches and charities and other institutions. The way a trust works is that Michael can be the sole trustee of his own trust, which means he can still have full control of the 3rd share that's been left to him, but he has the ability to distribute the capital and income of that trust to one or more of these beneficiaries here. That's what gives the trusts their tax benefits and asset protection. Specifically looking at the tax benefits and how that works, and we'll use again Michael as the example, we'll continue with him. In this example here, the inheritance, let's say, was 500,000. So Michael's share of the inheritance was 500,000. So Bruce and Kathy lived on for a few more years, and when they both passed away, their total estate was about 1.5 million, which is not uncommon when you take into account the value of a house plus some superannuation. So Michael gets his inheritance of 500,000. He invests it however he chooses to do so, whether it's dividends, managed funds, a rental property income. The tax on that 500,000 is 35,000 each year. the income rather, the tax on that 35,000, if he got his inheritance in his own personal name, the tax on that would be $13,000 per year. Whereas under a testamentary trust, what he can do with that $35,000 income is he can assign it to each of his kids. So in this particular example, he's assigned $17,000 to each of the two kids. He has three, but he only needs to assign it to the two kids, and his tax bill goes from $13,000 per annum to zero.
Josh, one of the things that I find that a lot of our clients ask about, and I'm sure it's been the same for you, is that they ask whether or not their children actually need to make payments to the Dolomite accounts for their grandchildren, and whether they all of a sudden have access to that income. And so it's important to realise that Michael can just reimburse himself from the expenses associated with raising his children, which I'm sure anyone who has children would agree, probably more than that 21,000, or in this case 17,500 per year. So it's an income splitting strategy, but Michael doesn't have to forego the use of the funds. He just gets to pay those expenses for the kids pre-tax.
Yeah, absolutely. And I get that question a lot as well. That's correct. He doesn't actually have to physically dole out the 17,000 to each child, but rather he can just keep a record of all the things that he's spent on them over the years, and that offsets the distribution, the notional distribution that he's made to them. And the way the tax actually works out is it actually effectively allows him to pay for necessities for the kids using pre-tax dollars, is basically how the tax works out. So it's quite a good system. That's the tax benefits of the testamentary trust. The other big benefits of testamentary trusts, and in fact, this is one of the benefits that I find, in fact, I find that clients actually prefer the asset protection benefits to the tax benefits. They love both, but in many ways are more interested about asset protection and making sure that the inheritance gets down the line. But there's a risk of the inheritance going L-shaped. So we call it avoiding the L-shaped inheritance. That's what we're trying to do. And so in this particular case, we'll use Jane as the example, because I already raised the concern about Jane and her husband Bart. Bruce has passed away up the top. Kathy has subsequently passed away. So everything went from Bruce to Kathy. Kathy has now passed away, and Jane gets her 1/3 share. Ultimately, Bruce and Kathy want to see Jane's bit go on to the grandkids. However, sometimes it doesn't happen. The inheritance goes L-shaped. And by that we mean it can end up with Jane's spouse, Bart. It can end up with the trustee in bankruptcy if something happens to Jane, or one of other potential claimants against Jane. And that can happen in a number of different ways, such as Jane receives her 1/3 share, but she subsequently dies and either doesn't have a will or has one that leaves everything to Bart. All of a sudden, Jane gets her 1/3 share, but then that 1/3 share goes L-shaped to Bart, and then potentially onto Bart's new spouse. Jane and Bart might also end up going through the family court, going through property settlement, divorce or property settlement if they're de factos. And the family court can make orders to have assets that Jane inherits as an inheritance passing to Bart because it's part of the property settlement. Or Jane could go bankrupt, and then the trustee in bankruptcy could step in and take a part of the inheritance. So there's a number of circumstances that can end up with the inheritance going L-shaped. And unless your clients are aware of these risks, by the time it gets to this point, it's too late for them to do anything about it.
Josh, it's really interesting that there was a study done about 10 years ago that estimated that only 30% of a person's inheritance trickles down to grandchildren level. So the L shape is actually quite a real thing, and we see it in a lot of cases. And so it's kind of a scary figure to think that 70% of your wealth won't reach down to a grandchild level, i.e. won't get past your children to grandchildren. I'm asked a lot by clients, can you use you put the testamentary trust in your will, so your wills become longer, you know, because it's got all the trust terms in there. Can you use the testamentary trust now, like before you die? And the other question I get asked too, and I no doubt you have too, is what is the ongoing costs of the testamentary trust will? Do you want to speak to those two things? Can you use it now, and what does it cost when you can use it to maintain it?
Yeah, short answer is you can't use it now. The only way you can get a testamentary trust is if someone gives you one. So you have to basically inherit it from a family member or loved one. So that's why it is very important that clients are aware of the options so that they can give the option to the kids in their will, because after they've died, it's too late to set one up. The other question you asked was around the cost of it. Let's say Jane, or let's say Michael received his 500,000 in a testamentary trust. Yes, there'd be some extra administrative costs in terms of accounting fees per year, but not exorbitant. And the tax saving of 13,000 per year would more than cover the cost, the administration costs of having a testamentary trust. But if at some point Michael's inheritance was lower, if he used the money or spent it and no longer needed the testamentary trust, then he could also wrap it up at that time as well, at some point in the future. So he's got all the options there.
It's an interesting thing, because a testamentary trust, once it crystallizes, which means once the person who left it in the will has died, and the testamentary trust is available to the beneficiary because it was placed in that will maker's will, that it operates usually very similarly to a family trust. And what I always find interesting is that unlike a self-managed super fund, which has lots of compliance and audit fees and all these rules surrounding how you can't use it, the testamentary trust is like a family trust. There are no audit fees, there are no registration fees, there are tax return fees. Obviously, you've got to prepare a tax return for the trust if it makes income, but that's about it. So it's kind of a low-cost vehicle that's highly tax effective, and relatively easy to run. Yeah.
Yeah, no, I agree, absolutely. And the benefit, as you say, there's no auditing required, so it's much cheaper than a self-managed super fund to run as well. So testamentary trusts are a great tool for your clients, but there's obviously a lot more than just wills and testamentary trusts that Bruce and Kathy might need to take into account. They could be interested in an inheritance agreement in terms of leaving assets to each other, but wanting the survivor of them to be bound to make some provision for the kids so that the survivor can't change the will and leave it all to someone else. Enduring powers of attorney, they're a very it can be a bit of a sleeper issue. A lot of people think that you can just pull the form off the web and it's nice and easy and just fill it out. They're a lot more complex than that. I often use the term that they are the most powerful document you can ever sign when explaining them to clients, because I think they are, because you're basically delegating the decision-making power for every decision you could possibly make in your lifetime to someone who can make decisions for you whilst you can't say anything to the contrary. So they've got to really consider who they want as that decision-making maker for both personal decisions and financial decisions. And also other clauses that needed to be added to the enduring power of attorney, because the standard one off the web doesn't cut it in a lot of cases. Bruce and Kathy need advice on super and how they should nominate beneficiaries. So for Bruce, who's in pension phase, perhaps a reversionary pension nomination in favour of Kathy, and or perhaps a binding nomination as well in favour of Kathy. For Kathy, the question for her is whether to have Bruce nominated as the beneficiary or whether to have the estate nominated as the beneficiary. And there's no right or wrong answer with that. There's advantages and disadvantages both ways. It really needs to be looked at in the context of their broader estate planning objectives. Having Bruce nominated directly as a beneficiary from Kathy's super means it may pass quicker. Downside is that there's no second level capture for it in terms of if they both die at the same time. Whereas if Kathy nominates the estate, her estate as the beneficiary, well, that covers the second level provisions, but it may take longer to administer, or it may require Bruce to get probate of Kathy's estate. Advanced health directives is another one that they should consider as well. So again, it's really not a question, or not just a question of what they say that they want or need, but more a question of the quality of the inheritance vehicle that they're getting. In terms of the testamentary trusts, tick all those boxes on the right-hand side. They give all these benefits to the kids, whereas their current standard wills, even though might seem on the face of it like those standard wills achieve what they want, may not actually completely fulfill what they're wanting.
So Josh, if a client says to an advisor, when an advisor asks, in their fact find, do you have a current will? And the client says yes. The right response to come back to is to inquire in relation to the quality of that will. What's the quality of how the gift is conveyed to the beneficiaries? Are there opportunities for asset protection and tax advantages by placing that inheritance within a testamentary trust casing to give to them rather than just outright? And that's something that the clients won't usually know until the advisor tells them. And I think, if they tick the box that says, I've got a current will, I've got an EPA, they might say, oh, I don't have an advance health directive, or even if they do, the question is, what is the quality of those documents? And do they speak to each other? Is it an estate plan, or is it just a disparate set of documents that haven't been thought through as a whole? So I think that's really useful, that information, and a great value add for clients, because in our experience they love testamentary trusts.
Yeah, they certainly do. They love the asset protection and tax benefits that they provide. And just further to that, just further to what Anne said, there is you can give general information on these documents, on testamentary trusts and how they work. Of course, whether it's something that's relevant for that particular client will depend on the overall circumstances. Particularly, as Kylie will show, you need to look at the overall estate plan when considering clients' needs, because Kylie's going to talk about the blended family case study now, which certainly requires an overall view of the estate plan.
Thanks, Josh. Yes, so we're going to move on to a second case study on one of my favourite topics, and that is blended families, estate planning. I love dealing with blended families and the myriad of issues, and I'm sure that they have financial planning issues as well as the estate planning issues. But first, I just wanted to go back to the comments that Anne made early on in our presentation about the contact-free and the estate planning solutions that we're offering, and the necessity that we've all had to be able to understand the Zoom forum and the various video conferencing forums, and obviously that's how we're providing this webinar today. And who would have thought the Brady Bunch would come back into our minds every time we click on a Zoom link to start a meeting. Okay, so moving on to the next case study, we're going to use the same people in this case study so that we've already met and been introduced to Bruce and Kathy. All the same circumstances apply in terms of who they are, their financial and their personal circumstances, except that Michael is only Bruce's son from a prior relationship, whilst Kathy has the 2 daughters from a prior relationship. So if we move on to their financial circumstances, exactly the same as Josh took you through in terms of the properties and superannuation and bank accounts. The only background information here that is different and relevant is the fact that the jointly held Camp Hill property was actually Bruce's home and residence from before he and Kathy started their relationship, and it has since been transferred into joint names. The Mount Gravatt property, on the other hand, actually previously used to be Kathy's main residence, and so that property is still in her name, even though they've commenced the relationship and they have transferred the jointly held Camp Hill property. You may or may not be aware that one of the reasons that this might have occurred is the fact that a home can be transferred between spouses from one person's name into their joint names with a stamp duty exemption. And so this is likely why this jointly held property is in that way, because it was relatively cheap for them to put into joint names. Whereas Kathy, because the Mount Gravatt property isn't their home now, is kind of stuck with that property in her name, and she has, in addition to not being able to transfer it without a stamp duty cost, it's also now accruing that capital gains tax. So Bruce and Kathy come to you and see you for some financial planning, and you again ask them, do they have up-to-date wills? And they say, yes, we've got up-to-date and current wills, and we leave everything to our own respective children because we want to just benefit our first families. Just like the question that Josh asked previously, what do you say to that? What is your response when they say, yeah, it's all sorted? The answer is really, well, hang on a second, what you think is going to happen, the way you think your assets are going to go, how you want them to go, isn't necessarily how they are going to go. You might ask them that question and they say, yeah, it's all sorted. We've left everything to each other, and then we've left it equally amongst the 3 children, nice and fair, nice and even. In response to that, you might say, should say, well, hang on a second. The survivor of you could change your will and cut out the children of the first of you to die. You could really comment, well, hang on a second, there's actually a really big risk of claim here against your estate plan. And what might seem nice and simple and fair is not necessarily going to be what occurs when one or both of you pass away. If we drill down into that and look at the detail of their assets and the detail of their estate plan, a really important aspect of looking at someone's wealth and their assets is to really educate the clients on how their assets actually are held and what that means in the context of death. most clients think of all of these circles that we've got on here as these pots as one big melting pot. They have access to these funds, they can use them however they want, so it's really their asset. But in fact, it's only the assets in their sole name, the assets that they hold individually or as tenants in common, that they will automatically pass under the terms of their wills. A lot of people don't understand the difference between assets which are held as joint tenants and those assets which are held as tenants in common. That's, their land, their property. So a jointly held asset, those assets that might be joint bank accounts, joint shares, or real property that's held as joint tenants, will automatically pass to the surviving person, where only the proportion or the fraction of the property that they hold as tenants in common will actually pass according to their will. Superannuation is not automatically governed by a will and needs its own estate plan, as Josh mentioned about binding death benefit nominations earlier. Family trusts, insurance, all need to separately be dealt with. And so that understanding and education is really important for clients to be empowered to be able to take control of their estate plan as well.
Kylie, how often do you see, I know I do, in blended family clients where they've said to you, oh no, the house is in my name, or oh no, we own it as tenants in common, and actually you do a title search and all of a sudden you find it's actually joint tenants, and you have to have that conversation with the client that it's actually going to go to your spouse when it's not what you want.
Yeah, absolutely. I think that not only is it important that what the title is reflects what the clients want, but I've even had situations where the title doesn't reflect what they thought they had even done, even if they understand these. So title searches are a really important aspect of the estate plan as well. If we drill down a little into the financials for the clients, we'll see very quickly that Kathy actually only has her investment property in her estate and therefore automatically dealt with by her will. The jointly held residence and bank account, they're held jointly or as joint tenants, and so they will automatically pass to the surviving person. So that means Bruce actually has no assets that are automatically part of his estate. The only asset Bruce can direct to his son Michael is his superannuation. And he has two ways to go about that. He can either directly nominate Michael, or he can nominate his estate so that it goes via his will, and preferably into a TDT as Josh discussed. So a really important aspect of the estate planning is looking at where these assets sit and fall. But it's going beyond that. It's going further than that, and even looking at, well, what do they mean when they say they're giving everything, or they want to give everything to their own children? Because even if we presume, well, at least they've got super nominations in favour of their kids, and so they're definitely going to give the super to their kids, and Kathy might have a will leaving everything to her daughters. What does that even mean in terms of the assets that they have? So if we drill down a little further in the asset ownership, one of the first things as a rule of thumb, we might look at is, let's presume a joint asset is 50-50, which is kind of the stamp duty underlying ownership presumption, and the bank account is 50-50. If we look then at the financial contribution to this wealth that they each have, when they in their own minds might be thinking, well, I'm giving what I have to my kids. Effectively, when you break that down, it looks like Kathy has 61% of the wealth and Bruce has 39% of the wealth. But you might remember the background to this is that technically Bruce contributed all of the Camp Hill property despite its ownership. And so if we add that Camp Hill property to the ownership that or contribution that Bruce has made, in fact, he has contributed about 54% of the total wealth. Doesn't really matter what they've contributed if their estate plan doesn't actually achieve their desire to leave everything to their own kids. So many assets are not automatically part of the estate and therefore the will. So we're going to see really different outcomes depending on who dies first or last. So let's look at how the estate plan might work out. If we look first at the instance where Kathy might die first and Bruce dies last, Bruce will go forward with everything that's held jointly. So he will receive the main residence, he will receive the cash, and he gets to keep his own superannuation. Jane and Bianca will receive all of Kathy's wealth that she's able to give, which includes the investment property, the superannuation that they will pay the death benefit tax on, and Michael, of course, receives nothing in that instance. Later on, when Bruce dies, if we presume in this instance the value hasn't really shifted very much in those assets, Michael then receives everything that Bruce went forward with, a total of $1.3 million. Jane and Bianca receive nothing later, but the percentages overall of the wealth that was passed to the children represents a 58%, 42% split, which you might recall isn't that much different to the percentages that they contributed. So that outcome might seem fair. If we flip it though and look at the situation where Bruce dies first and Kathy dies last, we see a really different outcome. In this instance, Michael gets to walk away with a meager 20%, and that's on the presumption that Bruce hasn't needed to access that superannuation significantly, and he also still has to pay the tax on that superannuation when he receives it. And Jane and Bianca end up with 80% of the overall wealth. The important thing here is to see the differences that can occur and highlight that to clients, that keeping their estate planning separate can result in really different outcomes where there's any benefit passing to each other. If we lay it all side by side, you'll see the percentage differences, whilst if Bruce dies last is kind of similar, we can't take the risk really that he's going to be the second to die, particularly given those heart concerns he has. Even if we go back to the second answer to your question, and that is they've left everything to each other and then to the children equally, those percentages at the second level will still not represent the contributions that they've made. So you can see why it's important not to presume that simple ideas and simple plans result in simple outcomes. The other issue that I mentioned earlier that is of concern in blended families, and a really important aspect to consider when we're looking at a plan that's going to be suitable for our blended families, is the issue of the risk of claim against an estate. So every state in Australia has the ability for certain eligible claimants to bring an action against an estate to say they weren't adequately provided for under the terms of a will or the assets that the person has left. Every state or territory has different laws. In Queensland, for example, we have spouses, married or de facto, children, including stepchildren, and certain groups of dependents who can bring a claim. Of course, each state generally has spouses and children as eligible claimants. The other peripheral claimants differ from state to state. So in this instance, we've got Bruce and Kathy claimants against each other, as well as all three children, both at first and second level, for them to be able to bring a claim against the estate. I'd say in the first example of them providing everything to their own children, even if we could achieve that, the risk is particularly high for the survivor of them to bring a claim against each other's estate. If they provide everything to each other in the first instance, the risk would be very great of the children of the first of them to die, bringing a claim later against the second spouse to die. So if Bruce dies first and leaves everything to Kathy, then Michael would have a good claim against Kathy's estate, having received nothing.
Yes, Kylie, it's interesting when you look at the cases in this area that the majority of estate claims are in the scenario of blended families, where the will maker has either left everything to his or her second spouse and nothing to their children from previous relationships, and therefore those children from previous relationships sue, or they want to leave it all to their own children, and their second spouse might have even agreed to that, but after the will maker dies, the second spouse or third spouse realizes that they don't have enough to live on, and they change their mind and they decide to make an estate claim. So it's definitely the area where most of the litigation in estate claims lies.
Absolutely. And I think that often that comes from the simple solutions to a complex problem. We want to have an outcome that is fair to everyone, as I say on the slide, and that might not mean that everybody is 100% happy and over the moon about what they receive, but it should, and we try and aim for our blended family clients to have a plan that's fair and takes into account those risks of claim, so that the outcome is one that everyone can live with, even if it's not the perfect solution for everyone. Some of the options, and of course every blended family is different, everyone's goals can be different. You know, we've made some presumptions that what Bruce and Kathy have brought in, they may want to give to their own children. Some people don't want that. Some people, despite their contributions, want a different outcome. And of course, part of the estate planning strategy and working through all of that with the clients is having the conversation to know what their goals are. But having a look at the situation with Bruce and Kathy, one of the options they might have is that Kathy actually gifts her super and her investment property via her will equally to Bruce, Jane and Bianca. We can have included in the will some super streaming options that allow Bruce to receive as part of his 1/3 share the super, because of course he doesn't pay the tax as the surviving spouse. For Bruce, we might look at the ownership of that main residence and try and claw back some of that contribution that he's made for Michael, with his 50% passing to Michael, with a bit of time for Kathy to get her affairs in order. And if he wants to make more provision for Kathy, better to do that perhaps from super. At second level, we want to potentially look at whether the gifts to the children should actually reflect the true wealth percentages, if that should be adjusted for anything they might gift up front to their own children. So that particularly it doesn't really matter who dies first or last, that the end result is going to be the same. That's a really powerful tool for our blended family clients who can't really see past right now, if I die first, what's going to happen. One type of document, an agreement that we can put in place, and we talk to blended families about all the time, are inheritance agreements. Doing the estate planning together, whilst it might seem counterintuitive when they just want to provide for their own children, is really important because they hold assets, they've merged assets together. They have gone ahead and already done some estate planning by transferring assets into joint names. The inheritance agreement can overlay an estate plan and get buy-in from both spouses to give them the security of knowing they can go forward and work out their financial affairs as it works for them now during their joint lifetimes. But they have the security of knowing their children are going to receive something later on. Of course, like Josh mentioned, all these other estate planning documents are just as relevant and important, and if even more so, different issues that arise in blended families. Enduring powers of attorney particularly, decisions that are made prior to death can have a huge impact on what happens after someone passes away, such as selling an asset which is actually gifted to the children in the will. Who should the power of attorney be making those decisions? Should the children be involved? Should the spouse be involved? Of course, the estate plan will dictate some of those decisions, but also the dynamics of the family. They need to have those robust financial clauses as well in blended families, just the same as Josh was talking about. And the superannuation is also really essential to the estate plan. We need to factor in the financial advice around the taxable and non-taxable components of super to just determine who might be best to receive it and how to divvy up the estate. But the nominations, then we need to also factor in the higher risk of claim in a blended family scenario and decide, do we swing that into the estate where we can weigh up the benefits of testamentary trusts, or do we keep it outside of the estate and thereby, in all states other than New South Wales, reduce the risk of claim against the superannuation? Obviously, the answer to the question of what the superannuation nomination should be is dependent on their estate plan, but those options are really important to educate the clients on, that the superannuation nomination isn't an isolated decision. It's a decision that's part of the whole of their wealth and where they want that to go.
So Kylie, if a client talks to their advisor and asks them who they should nominate in their binding nomination, or should they do a reversionary pension nomination, what would you advise the advisor to say?
So in terms of the nomination that they should do, like I said, it will depend on what they're wanting to achieve in their overall estate plan. In this instance, obviously the difference is whether they decide they want to benefit their own children first, or whether they want to benefit each other and then secure an inheritance for the children with something like an inheritance agreement.
And yes, and I'm thinking of the compliance aspect. So, you know, if you as an advisor are confronted with a question from a client that says, well, what should I put? Because sometimes, you're downloading the forms for Australian Super or Sun Super or whoever, and the client just wants you to tell them what to put in, or they're thinking, oh, I'll just nominate my spouse. You should probably just stop them there and say, look, this is, I can't advise you on who to put in because that would be legal advice. That is a legal solution. You really need to make that decision, like Kylie has just said, with all of the estate plan in mind, even the enduring power of attorney and who can renew and create it and so on. That all has to be done in context. So yes, you can provide them with information on the taxation of concessional components and the tax-free element and untaxed element and so on. But it would be good from a compliance point of view to stop short of actually providing them with the actual solution. And what they should do is then go and get their estate planning advice in the context of the will and the other documents that they're doing.
Yeah, absolutely. And I think that that's a really important point. We don't give the financial advice about the best, what the tax is going to be, or how it might work best for the recipient from a financial point of view. And so it's actually really a partnering decision. We don't make the decision on the binding nomination in isolation to the financial advice, just as the actual nomination and who should be nominated and how that all works with the estate plan is something that we would advise on. So we really look at the superannuation estate planning as a team approach in terms of those nominations and what's best. So just to recap and go back to the questions that were asked right at the start, it's not so much about having the answer. It's not so much about having the estate plan all thoroughly sorted and worked out for your clients. Like Anne said, that's legal advice. But it is important to understand the ramifications of what might seem like a simple yes or no question. Do you have a current will? And having that ability to give them a little bit of information that makes them realise that there's something better. There's, like Josh said, there's a better plan. There's a better way to approach all of this. I'll hand that back now over to Anne.
Okay, well, thank you very much, Kylie and Josh, and I hope that was really practical and informative for you when you're having those estate planning conversations with your clients, and it's such a value add to them to understand these concepts. And one thing I say to our advisors often is that clients have come to us and thanked thanked us for getting their estate planning done. And I've said, well, actually, thank your advisor, because if it wasn't for them, you wouldn't know any of this, and you'd probably have no way of knowing without having an accountant or financial advisor who's told you this. So it's a wonderful thing that you're doing in that regard. And to help you out with your estate planning conversations with your clients, we have developed and spent a lot of time and very excited to have developed the Advisor Hub on our website. And the Advisor Hub has a whole raft of support tools for you to access, and you can access them without having to register or log in or anything like that, because what we're wanting you to do is to share them with your clients so that they understand the estate planning process and the importance of it. So we've got an extensive range of fact sheets, which you will also find useful, and your clients who love to read will really enjoy. There's a great one on testamentary trusts and a great one on estate claims and the L-shaped inheritance. We also have showcased there our full range of estate planning services. So we cover all estate planning from very simple, very standard, to complex, very complex, and all of the raft of things you can get, including inheritance agreements, super advice, tax strategies for death benefits, and so on, is all part of our offering. We also have booklets and brochures. We have an estate planning health check that you can take your client through, red flags, trigger events, all sorts of tools that you will find can support you when you're having those conversations as well. And of course, we have our webinars, and we've just also released a very cool client video called Why a Will Is Not Enough. And it is a video that I would love you to share with your clients who are on this estate planning journey of why it's so important. And it's all done in layman's terms, so it's very easy to understand, uses a lot of visuals so that the client hopefully is engaged and it keeps their attention. So please go onto the website. It's there under the Advisor Tools section for you to download or to just click on and share, because it's on YouTube as well. And of course, we have been doing training and client presentations for over 10 years now. We appear at a lot of PD days and retirement seminars and so on. We always try and make our estate planning topics interesting and engaging, because estate planning is a very interesting and engaging topic anyway, so it's not hard work to do. So you can go on there and or contact us to ask questions on how you can get in-house training for yourselves or for your clients. We also do quite a bit of compliance support for firms or super funds who want us to check out their estate planning written material in their SOAs or in their fact sheets. And we're happy to do that for our referring advisors. We build a strong relationship with you guys, and we want to help you with your estate planning in whatever way we can. And we always also say, if you have a question or about a client or one of your clients, they don't have to mean that they come to us. You just email us and ask us the question, and we'll do our best to give you good guidance on how to talk or help them with their estate planning issue. So, all right, well, that brings us to the end of the webinar. Please get in touch with us. Please go and have a look at the Advisor Hub and check out the website. And stay tuned for our next webinar, which will be on enduring powers of attorney and advance health directives. Thank you very much for tuning in.
Thanks, everyone.
Thank you.